Go on record for the review calendar. I'll go in the order of the calendar. Dakota Galvin, Shane Maloney, Lucas Peters, Charles Smith. Smith, come on up and have a seat if you would. You bet. If you have moral support with you, they're more than welcome to come up if they want to as well. Smith, how are you?
Good, getting better.
That's good. Docket entry says out of compliance, the treatment. And positive UAs. How's life?
Life's been good. Life's been good. Still doing 3 times a week.
Was I missing something? That looks like all the positive UAs are for, are you able to hear me okay?
Yeah.
Are for THC.
Yeah.
Positive for anything else?
No.
Have you discussed the issue of THC? I know THC is as legal as alcohol, but they're the treatment.
Since I different counselor, she's no longer there. Just to make it clear, I won't have one of those.
Mr. Smith, my concern here is public safety. As, I'm glad to see that you're engaged in treatment. THC, that's kind of a touchy topic. On the one hand, it's legal, but on the other hand, it's illegal to drive while under the influence of THC. I'm certainly hoping, I haven't seen any indication of any new offenses. I'm certainly hoping that you're not driving while you're using or under the influence of anything. It's alcohol or THC.
So it was in my system when he brought it to my attention that it was going down. But
yes, the numbers
on that time of March, it was going up a little bit. It's because I had that one lapse. I had to clean out everything, throw everything.
my age, I'm well aware of back issues. Hence this.
Yeah, I'm still on LNI actually for the 3rd year for shoulder surgery. So.
Hey, we're here to complain about it. So with that, Mr. Ratfield, any input you want to? That's I'm inclined to take no action here. On the one hand, that is a technical thing, and yes, total abstinence is a requirement for virtually all treatment agencies. It's understandable what you're doing. I don't see any new offenses, and that's the most important thing. And you look healthy and together, and that's says a lot to me as well. I'm inclined to take no action at this time. This is, all for March. We'll just see what happens, when we get our next report. Life going okay otherwise?
Yes, sir. Yes, sir. Everything's going really well.
That's,
I have
I'm glad
moved,
you're.
so what I have a new address, so what I'm gonna spread that.
Oh, update that.
Update them to as well.
Wonderful. Yeah,
So
make sure.
I try to call the center system like every other month. I tried it 2 or 3 times. I tried the secure line. I tried the priority line. And all it does is give me an answer machine because they needed some.
Somebody once said, trust but verify, and that's, they're all the same. They want to make sure because they get snowed on a regular basis, so they just want to verify. So that's, but I'll strike the hearing. I'm going to take no action. I'll find you partial compliance, almost full compliance, and you're compliant with the most important things to me, and that's no new offenses and attending treatment on a regular basis. Yes, you're staying up with that. All I can do at this point is wish you the best of luck. It looks like you're getting this behind you. It is a diversion agreement, and I'll find you're mostly in compliance with it, and leave it at that. City's not making any motion to set anything aside, and that speaks well. Good. I'm going to wish you the best of luck. You take care.
Okay, thank you, sir.
Strike the hearing and find you in partial compliance. Good luck. Keep it up. Sir, are you here for court? You in the back. And your name is? Mr. Peters, come on up and have a seat if you would. Good morning. You were cited, you're on an SOC, stipulated order of continuance. There's a new violation alleged, and you haven't made any payment on your fines. What's going on?
Oh, fines, be taken care of.
Cool. The new violation, what would that be? We can certainly. Nothing, any protection order violations. It looks like the SOC ends May 9th here. Which is the day after our next court date, which would be May 8th. Is it a diversion? Are you going to be able to pay the $250 by May 9th? That's. We can reset the matter to.
Yeah, why don't we reset, provide Mr. Peters some additional time, extend the SOC.
How about by the 22nd of May? Are you, yeah, I don't want you to guess. We can go out further. Let's reset the matter for the 22nd, and it sounds like you're going to get the benefit of the bargain as long as you don't get any further trouble and pay the $250. Yeah, the new violations, yes, violations are a violation of it, but I think the important thing to the city and to myself, of course, is that the behavior that got you in trouble here has not been repeated. We've seen that. I'm signing a order resetting the matter to May 22nd at 8:15 in the morning, Mr. Peters, and I want you to get a copy of today's order It'll have the date and time on it at the window. How is life going otherwise? You look like you were trying to catch up on your sleep there in the back. Everything's okay? Are you working at all or? I'll leave it at that. I'm gonna wish you the best of luck and we'll, now, if Mr. Peters is paid in full and has no further violations, city willing to waive appearance.
Yeah.
As long as you're paid up by your next court date, the 22nd of May, and you don't have any new offenses from now on, the charge will be reduced in accordance with the agreement. If there is any problem with making the payments, you need to show up on the 22nd. Any question at all? Mr. Peters, good luck to you. Get a copy of the order on the at the window before you leave, and it's going to be a beautiful day. Enjoy it. Good luck to you. That leaves us with docket numbers 1 and 2. Dakota Galvin. Pardon, and nobody's, and Shane Maloney. With regard to Galvin, it looks like there's an SOC ending, which ended, and with the money,
I mean, city's just gonna close it.
just close it as is.
Yeah, I don't, step 3.
Give them the benefit of the bargain, away the
Yeah.
fine. Right. How about Shane Maloney? That's a DUI with a victim impact. That's a little more problematic.
Yeah, let's go 2,500.
So ordered.
Yeah.
2,500 non-appearance. Bond will issue cash or We can go on a little bit early for the private counsel matters. And attorneys, as usual, are appearing on Zoom. So bring up. It is a little bit early, but I will call the matter of Yelm versus Kevin Golden. Counsel's on Zoom. Mr. Golden, good morning. Have a seat. Matter set for a pretrial.
And good morning, Your Honor. Attorney Kate Lazarick on behalf of Mr. Golden, who is present in the courtroom. This would be a defense motion to continue at this point. I have loaded a motion to continue in O courts and have talked about that with my client.
Looks like the request is a reset to June 5th at 9 o'clock. The city have any?
No objection.
Hearing no objection, we'll do that. There is one issue. There was a city got notice of a failure to in the SCRAM system.
And that is correct, Your Honor. We received the tamper report from the court as well. I spoke with Mr. Golden at length about it, and he has no idea as to why that happened. I instructed him to get a UA from his treatment provider as soon as we got that tamper report. And he did that. We filed it with the court. It shows that there was no alcohol, no other drugs in his system at that time. I believe the UA, I want to say, was about 3 or 4 days after the alleged tamper. I also had him go back into where he got the scrim bracelet and they had it tightened. I think there was an issue with it moving up and down his ankle. It wasn't tight enough. So he had it tightened and there has not been any issues since. So I understand that the court received that report, but I have had multiple clients lately that have had false tamper reports, and I think that is the situation here, Your Honor.
I would certainly hope so. I might indicate that I had to read that tamper report about 4 times and not having any knowledge about electrical engineering. It was difficult for me to understand exactly what was being contended. I didn't realize you could measure distance with voltage and still don't understand that.
Yeah.
Golden, it is your record is very concerning. And I'm not going to take any action, but I will tell you that there better not be another violation. This one did not allege any alcohol use. It just simply alleged a blocking of the effectiveness of the device. But it's very important that you be in full compliance, whatever you need to do to stay out of custody. At this point, you need to do. Stay in touch with your attorney. We're resetting the matter to June 5th at 9 a.m. Any questions at all? Any conditions earlier set remain in effect, and we'll see you back here on June 5th. I do need you in court in person. Your attorney, if she wishes, can appear by way of Zoom. Stay in touch with your attorney. Be back here on June 5th and abide by the conditions earlier set.
Thank you, Your Honor.
Concludes the hearing. Mr. Golden, you get a copy of today's order at the window, and we'll be sending your attorney a copy of today's order as well. Any questions? Take care of yourself. Thanks.
Thank you, Your Honor. Have a good day.
Thank you. Boy, that was, thought I got the Going to address docket number 1, Yelm versus Armando Azevedo Hernandez. Mr. Hernandez, come on up. And Mr. Bolden, once again, do you solemnly swear or affirm that you will accurately translate from Spanish to English and English to Spanish all that is spoken of in this matter? Yes, I will. Thank you. Mr. Duenhalter, good morning.
Good morning, Your Honor. May it please the court, Martin Duenhalter on behalf of Mr. Acevedo Fernandez. Your Honor, we had continued this several times for discovery, and philosophically, it comes to mind that the practice of law is much well served with communication rather than automation. But thankfully to your court clerk and Mr. Ratfield, I now do have the discovery. And of course, I thank those government entities for that. I reached out to Mr. Ratfield, but I think he was unavailable to talk about this case. I did actually speak with him, and then I got the discovery. So obviously that was a good move. So we're moving forward. And unfortunately, if we could continue for a couple of weeks, we might be able to get this closer to resolution now that I can examine the police report.
Next available dates would be May 8th, May 22nd.
May 8th?
May 8th would be the next.
And what time are those at?
9 o'clock.
I have a pre-trial. I'd like to do it that day. I have a pre-trial that day, and I'd like to run down to Yelm actually and try to get this done. Does the court usually, could it run like till 10?
We're pretty much here all day. That's it. If you can be here at 10, well, absolutely.
Okay, I'll write it down for 9 o'clock, and maybe I could get my pretrial in Pierce County covered, and then I'll reach out to Mr. Ratfield, and maybe we can get this thing taken care of. Thank you very much, Your Honor.
We'll do is reset the matter at your request. I'll need a motion to reset that I can sign. We'll reset it to May 8th at 9 o'clock with the understanding that we won't look for you until a little later than that.
Thank you so much. I appreciate that. And I can definitely log on to O Courts and would sign whatever is prepared for me.
Mr. Ratfield is preparing the motion.
Perfect. Thank you. Armando, give me a call. I have to go to a pretrial across the street right now, but in about an hour and a half, give me a call.
Did you understand? Your attorney wants you to call him about an hour and a half from now.
Thank you very much.
Your attorney be back here on the 22nd of May.
Oh, wait, did you say 22nd or I put May 8th?
May 8th. I misspoke.
Thank you. Thank you.
May 8th, 9 o'clock. I'm going to sign an order to that effect. I want you to get a copy of that at the window outside the courtroom to the left. And we'll also send your attorney a copy of today's order reset.
Perfect. Thank you. Does that mean I don't have to log on and do a bunch of mumbo jumbo right now?
Yes, it does.
Perfect. I'm late somewhere else. Thank you so much, Your Honor. Thank you for taking the case this morning, and I hope to see you healthy, happy, and wise on May 8th.
I'm just hoping for healthy and here wise. I'm going to work on that.
Sure, we'll get there by then. Thank you, Your Honor.
Right. Mr. Duenhalter, thank you. We'll see you on May 8th.
Take care.
Good one. Okay. That concludes the matter. Mr. Mold will help you with today's order. It's going to take a minute. That's still being prepared.
Should be up.
There it is. Mr. Bariga doing? Morning, I'll call the matter of Yelm versus Daniel Bariga. Mr. Ansing is on Zoom, as is Mr. Bariga. We'll address that matter at this time.
Good morning, Your Honor. Austin Onsing on behalf of Daniel Bariga. Mr. Bariga is also on the Zoom platform today. Your Honor, we are ready to proceed with a disposition on this matter by way of SOC amending to reckless driving. I have reviewed that SOC paperwork with Mr. Bariga, so I've reviewed it with him line by line. He understands what he's entering into, the rights that he's given up in order to enter into this agreement. He understands the nature of the charge that is associated with this agreement and also the nature of the resolution if he were to successfully comply with all the conditions. Your Honor, I've reviewed all the conditions with him. I have been unable to log into OCourt to sign that SOC document, Your Honor. I keep getting an error message from OCourt. So I have reviewed it with Mr. Bariga. We reviewed it last night, but I'm unable to sign for both myself and Mr. Bariga at the moment. I'm trying to work through that.
We're experiencing the same thing here. OCourts is having an issue down here as well. That's I'm sure the city's willing to waive signature based on your representations. Good morning, sir. For the record, is your full name Daniel Alexander Bariga?
Yes, Your Honor.
Morning. Do you disagree at all with anything your attorney just indicated to the court?
No, Your Honor.
I'm looking at in OCourt a SOC stipulated order of continuance, which is basically a contract under the terms of which if you do what you're agreeing to do, 60 months from now, the city will amend the charge to the much less serious one of reckless driving, and it'll go on your record as such.
Yes, Your
Honor. The agreement that you're making here is that you will not reoffend. You will not get another offense of this kind. You'll appear in court as directed. You have no criminal law violations at all, and do not drive under the influence or under the impaired by either alcohol or any drug. $900 is the court cost in the matter. You can pay that over time, but certainly within the 5 years. And you're to continue with your dual diagnosis, mental health / SUD treatment with the Veterans Administration. Do you agree with that?
Yes, Your Honor.
Now, in return for the agreement, you've given up your right to go to trial. If there's a violation and the city proves that, we'll have a hearing based on the police reports, and that would most likely result in a conviction for a pretty serious traffic criminal violation. You realize that?
Yes, Your Honor.
Bariga, that's I'm approving of the order. I'm going to wish you the best of luck with this. I think a very important part is to continue with any counseling that you're receiving. I think that's very important. If there's any problem making the fine payments, let us know, and that is certainly something we can deal with, and that is not the most important thing to me. Mr. Atfield, anything from the city? No. Mr. Ansing, anything further?
Nothing further, Your Honor. I will note I was able to actually get into OCourt, so I did sign that SOC document for both myself and Mr. Bariga, just for the court's record.
Wonderful. I now see that. Mr. Bariga, what I want you to do, we're going to send your attorney and you a copy of the agreement. I'll go over it again if you would, and if you have any questions, give your attorney a call, okay?
Yes, Your Honor.
I'm going to wish you the best of luck with this. Your attorney has put you in a position where you can minimize the harm done to yourself and your license, but you have to comply with the agreement.
Yes, Your Honor. Will do.
Good luck to you, sir.
Thank you.
Francine, good luck to you as well. Take care.
Thank you, Your Honor. Have a good day.
You as well. Next call the matter of Yelm versus John Conn, C-O-N-N. Mr. Conn in the courtroom. Is not. We'll go to Mr. Melvin. Mr. Melvin, good morning. You're muted.
Apologize.
Now I can hear you. Good morning.
Good morning, Your Honor. Rob Melvin on behalf of Mr. Khan. We're just having him appear through counsel this morning. I had a chance to speak with him. I didn't want him to miss work if he didn't have to. We just need to, I'm just asking the court to continue this 30 days. We did get an order uploaded to O courts. I've been playing phone tag with Mr. Ratfield, haven't been able to talk to him about the case. So I just like to go out to June 5th. Did have a chance to go over everything with Mr. Khan on the phone this morning.
Bradfield, any objection?
No
Hearing no objection, I'm citing an order resetting the matter. We'll be sending your client and yourself a copy of today's order. Anything further in this matter?
No, Your Honor. Thank you.
Mr. Melvin, thank you. We'll talk to you again your next court appearance.
All right, have a good day. Thank you.
You as well. Mr. Van Victen. Morning, Mr. Van Victen. We'll take your matter now. Call the matter of Kinsey DeFord. Is Mr. DeFord in the courtroom? He is not.
Your Honor, Mr. DeFord will not be present.
Okay.
I think Your Honor's on mute. I can't hear you.
Pardon? Are you able to hear me now?
A little bit.
I'll speak a little closer to the microphone.
Okay. Your Honor, you may recall from my last appearance that Mr. DeFord was taken into inpatient treatment and subsequently got an evaluation, which has been supplied to the city. The conclusion of the evaluation is that he needs extensive inpatient treatment. The move from Discover Recovery to Spokane was attempted earlier last week, or I believe this week. Along the way, there was a stop at a rest stop for my client to use the bathroom. He didn't emerge from the bathroom, went on the run, but then turned himself in 2 days later, which is a very good sign. Admitted that he had used again and returned to Discovery Recovery, where they will have him out in 2 weeks and then transport him to Spokane for a detox situation there for 12 weeks. Your Honor, I think the most sensible thing to do is to note the FTA and to schedule a hearing for 3 months out. The alternative being just to set a motion to quash when I am in contact with my client, and he is working, as Your Honor knows, relapse is a part of the recovery. He's been deemed not competent by the Puyallup tribe and has therefore had a guardian established over him, but it's not the same as in state court guardianship. It's because of his current substance abuse, Your Honor. So it's a restorable situation. We're not talking about a 1077 situation. But if he were here today, because he's been stripped of contractual capacity, he wouldn't have been able to sign anything anyways. So, Your Honor, while I wish the relapse hadn't happened, I'm glad that he did turn himself in, that he admitted the use, and that he is on the road to recovery, long though that road will be.
Part of the process. Glad to hear that he turned himself back in and he's back in treatment. What I'm inclined to do is note the non-appearance for speedy trial purposes and reset the matter. Mr. Van Victen, how far out would you think be prudent to go given the treatment circumstances?
Well, Your Honor, unless Your Honor is willing to allow him to appear remotely at these hearings, he will not be done with treatment in Spokane until, if all things go right, 3 months from now. I don't know what sort of accommodations are made for people to appear remotely while in inpatient situations in that facility in Spokane. But if Your Honor is willing to set this out 3 months, that would be appreciated so that he theoretically could participate thereafter. If Your Honor wants a shorter set, I can work to see if there could be a Zoom appearance, if Your Honor is willing to accommodate that.
What I'd be inclined to do is set the matter out to July 3rd. Just to track the matter, see where you are now. I'm assuming that he'll be in a blackout period while he's in treatment, and usually a Zoom appearance would be possible, but not knowing that, what I would prefer to do is reset the matter to July 3rd and just see what things where we're at then, where we are.
Understood, Your Honor.
Mr. Hatfield, we'll do that. We'll be sending you a copy of today's hearing notice, and we'll wish Mr. DeFord the best of luck.
Good morning.
Thank you, Your Honor.
Hearing as well to his last
You got trial
notice,
today?
which may or may not get to him.
Good.
Any other questions?
With your permission, may I leave the Zoom court, Your Honor?
Yes, no problem. Yes. Anybody else? Mr. Hadfield, I do see a motion to continue on behalf of Tomas Rivera. Was he? Nobody is. Court's document indicates May 8th at 9 o'clock. We'll reset the matter to then at the request of counsel, noting the non-appearance for speedy trial purposes if necessary. Any other private counsel matters ready to go at this time? Morning, sir. Have a seat. Go ahead. Full courts is not as cooperative as we would want this morning, but there you are. Morning, sir. Your full name is?
Nathaniel Benton Jr., sir.
Address the matter at this time. I'll defer to counsel for the status of the matter set for a pretrial at this time.
Yes, Your Honor.
There is I'm certain that there is no objection to me signing an order of dismissal. With or without prejudice?
Without.
Without prejudice. Mr. Ben, the matter's being dismissed at this time. What without prejudice means, the city can choose to refile the matter at a later date if they discover new evidence or reconsider the matter at all, but it's rare that happens. It happens almost never. So as of now, the matter is dismissed. I'll sign an order to that effect. Any questions at all?
No, Your Honor.
I'll wish you the best of luck. You take care. Get a copy of today's dismissal order at the window outside the courtroom and to your left. Ben, good luck. Good morning, sir. Morning, Your Honor. Finally back to the dashboard. Defer to counsel for the status of the matter. And your client is? Did he have any response? I'll need something in O courts to effectuate that. May 8th? May 8th or 22nd? 22nd. 22nd. Pardon? Yes, 9 o'clock. No, generally, I'm looking at a order on pretrial conference form. Usually a simple motion to continue is, but this will do. Readiness hearing, May 22nd. We'll call it a readiness hearing. Well, I don't see any point in setting a trial date at this time. Usually I let the parties exhaust negotiations before we do that. I'll defer to counsel. Mr. Getty, I'm good at mispronouncing names. So resetting the matter at the request of yourself to May 22nd. Stay in touch with your attorney in the meantime. Law-abiding behavior, of course, remains in effect. Yes, any questions at all? No, Your Honor. Good luck to you. You can get a copy of today's order at the window outside the courtroom to your left, and we'll see you back here May 22nd. Thank you. Have a good day. Counsel, thank you, ma'am. Juan Martinez Parada. Mr. Bold, that's a matter for you. That's a notice was sent to Mr. Martinez Parada. That's and apparently he's moved on. I guess we'll the city will when the city's free, they'll make a motion to warrant the matter. This is docket number 11. Mr. Martinez Parada apparently is dropped off the radar. Notice sent to him was returned, not deliverable. City wish a warrant?
Yeah.
So ordered. What now? If somebody on Zoom? Mr. Ensing, yes.
Hi, Your Honor. I just had one quick clarification on the Barriga matter.
Okay. We'll go back to that, matter. Go ahead.
And Your Honor, on that case, there was a pretrial ignition interlock device that was required, and I just wanted to clarify with the court that they would be moving that pretrial ignition interlock device restriction.
Absolutely. Absolutely.
Okay.
Hey, Mr. Ensing, you have a good day, and we'll make sure that that's done.
Thank you, Your Honor. Have a good day.
Take care. Have a good one. Yeah. Okay, great. Okay. Don't hurry. Any other matters ready at this time? Good morning. Mr. Starkman, good morning. How are you? For the record, full name, Jeremy Andrew Stockman.
I've got an assessment and some treatment documents, may I approach?
Absolutely. And
Plea forming reports this morning with my client, he did sign.
Mr. Stockman, I'm looking in O courts at a statement of defendant on plea of guilty to an amended charge of reckless endangerment. Plea form tells me you're 31 years of age. You've been through the 12th grade in school. Have you gone over the plea form with your attorney? And if you had any questions at all about what it meant to enter a plea of guilty to a criminal matter, was any question you had answered? If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeals, simply a sentencing which could be up to the maximum, that being 364 days jail and or a $5,000 fine, regardless of what's recommended by the parties. You realize that. That in mind as to one count of reckless endangerment alleged to have occurred within the city of Yelm on January 18th, 2025. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And I will find that your statement in paragraph 11 does satisfy the factual elements of the offense. City's recommendation as to sentence?
Just that following the plea, Your Honor. 360.
Like a $250 fine, law-abiding behavior. Stockholm, I'm turning to your attorney for anything he wishes to state at this time.
Thank you, Your Honor. This is a agreed recommendation that we'd ask court adopt. I'll let the court know that Mr. Stockman has been an excellent client to work with. He's been very proactive, as the court can see. He made it in for his assessment last month, immediately got enrolled in the follow-up program. So it seems to be kind of a two-phase program consisting of about 6 months. Spoke with his counselor earlier this week when I was trying to get these documents for the court. They had great things to say about Mr. Stockman's participation, so that was really good to hear. Seems to be taking this matter very seriously. There were some pretty significant legal issues in regards to the administration of the breath test on this. There was no valid sample produced, so we felt this was a fair, appropriate outcome, and we escorted that. Thank you.
Mr. Stockram, you have a right of elocution. You can tell me anything you wish to at this time. You don't have to say anything, but if you want me to know anything about the situation here, now's the time to let me know. This is kind of a novel, but an excellent way of resolving the matter for a number of reasons that I won't go into. And your attorneys put you in a very good position here, but the rest of it is up to you. I'm going to follow the recommendation, but it's very important, and that's going to be a requirement that you continue with your counseling until you're discharged. The other part is, of course, 364 days suspended on the condition you have no criminal law violations and comply with the rest of the conditions that are set forth in the plea form. Most importantly is don't drive unless you're licensed and insured. Complete the treatment as I indicated. No criminal law violations. Whatever recommendations are made by way of victim impact panel, by your treatment are to be complied with. $250 fine, that's the least important thing. If you have any issues making the fine payments, just let us know and we can certainly deal with that. I'm going to wish you the best of luck with this, your situation here. Again, the problem and why a DUI conviction is, a pretty serious matter is the number of people we kill every year. Save your own life, save the lives of everybody else there on the road. I'm going to wish you the best of luck. That's the best I can do. Your attorney has positioned you to really minimize the damage done by this event. But the rest of it is up to one person, and that, of course, is you. Any question at all? I'll sign a judgment and sentence just as soon as O Courts lets me do that. Now, before you leave, you can get a copy of today's paperwork at the window outside the courtroom to your left. What I want you to do is, when you have time later today or this week, go over it carefully, and if you have any questions, give your attorney a call. Any questions based on anything I've said? Once again, I'm going to wish you the best of luck. You take care of yourself and have a good life. I'm reasonably certain that the treatment that you've been engaged in so far has led to a pretty marked increase in the quality of your life.
Your Honor, does the court want me to take him out to the front window then?
Absolutely.
Okay.
I'm signing right now. O Courts has cooperated to this extent. Paperwork is signed. Mr. Stockman, good luck to you. You take care of yourself. Okay.
Thank you.
Thank you, counsel. Take care. I am going to assume that everybody else that is here is either here early, waiting for Mr. Haverco to show up, or if there's anything else, let me know. Mr. Haverco is over at the Nisqually Tribal Jail due to a unfortunate accident on I-5. The northbound traffic is a parking lot apparently from College Street up to past the Nisqually Bridge. And what time are you scheduled for court? 9 o'clock. And your name is? Last name? Ten o'clock. 10 o'clock. And your name is? One o'clock. You bet. Now, Mr. Haverco will be here and he'll be appointed to enter a plea in your behalf. If you want to wait for him and just resolve your matter this morning when he has time to, or come back at 1 o'clock, I'll leave that up to you. Sure. At 1 o'clock it is. Okay, thank you, sir. Anybody else have a question? Take time. On record. Going to apparently address a matter on the 2:30 calendar, and that would probably be,
Your Honor, good afternoon. My partner at the firm, Phil Sue, has a matter. Craig Keene on your 2:30.
docket number 2, Craig Ethan Keeney, yes.
Yes, Your Honor. Mr. Sue has to be in Superior Court this afternoon. Unfortunately, he's not going to be able to handle both matters. He asked if I could do a motion to continue on this. I have authority to waive this meeting here.
No problem, no problem. We'll reset it. How far out would,
I think just 30. Is there a normal course? Whatever.
there it opens. Reset to May 22nd at 2:30 in the afternoon. Got it. Notices will be sent.
Thank you very much, Your Honor. Have a good day.
Yeah, and you as well. Take care. Back on record for the, finally, for the 8:30 matters. Good morning, Mr. Haverco. I can see you. Are you able to hear me? I cannot hear. I can see you, but I cannot hear you. Are you able to hear me?
I can hear you. Can you hear me, Judge?
Yeah, there you are. There you are.
This on the video screen, I'm not seeing, as long as you can see us, that's great. We can't see us. Usually there's a video window that also shows us that we're on, but as long as you can see us, then we're good. Because we can see you.
I can hear you, but, well, that's.
Can you see us?
I can.
You
Yes.
can, okay.
And hear you.
Oh, good. Okay. So this is Miley Cavey. She's item numbers 1 and 2 on the 8:30 in custody calendar. And she comes before the court for arraignment on a couple of cases. They're a bit older. I've had an opportunity to review those cases with her and had an opportunity to review, what an arraignment is, to reread the charges in open court, the elements the city would need to be proved, the maximums that could be imposed. She understands those rights. But with those rights in mind, she'd like to waive formal arraignment and proceed with a plea. I've reviewed with her the statement of defendant on plea of guilty with her, and I think she understands what she's doing and everything, so I'd ask your honor to inquire.
Good morning, ma'am. Is your full name Mary Kawe?
It's Miley Marie Quay, yes, sir.
I apologize for mispronouncing your name.
It's okay.
Mr. Averco to represent you. Do you disagree with anything at all that he just said?
No, I completely understand and agree with what he said.
I'm looking at one count of theft in the third degree alleged to have occurred on March 2nd, 2022. There's a plea of guilty in the O court system on that, which it references a dismissal of the earlier charge. Have you gone over the plea process with Mr. Haverco?
Yes, sir.
Had any questions about what it meant to enter a plea of guilty to a criminal matter?
No, sir. I do understand.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum of 364 days in jail and or a $5,000 fine. You realize that?
Yes, sir.
With that in mind, is one count of theft in the third degree alleged to have occurred within the city of Yelm on March 2nd, 2022. How do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
I would say yes.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. Recommended sentence is all jail time suspended, 364 days on the condition you have law-abiding behavior.
Yes, sir.
Mr. Haverco, anything further?
Nothing to add, your honor. She just wants to take care of this today and move on, and we ask the court to follow the recommendation.
Any recommendation is to fine?
City, because of her in custody status, the city was not recommending any financial obligations.
Ms. Coy, you have a right to tell me anything you want, anything you wish to tell me.
Yeah, actually, I do not have a job right now, but I'm trying to turn my life around, and I have 7 other warrants out of county that I'm gonna be moving on to take care of. And I am gonna be aiming for some electronic home monitoring out of county, which will cost quite a bit for my parents as it is. And I'm just hoping that I can waive any financial obligations because I really don't have the means. And I will make it to any court dates moving forward, because I don't want to have to take care of this again. I did this last year and served time on these same cases and missed court, and so I'm back serving time again. So I'm just trying to get my life turned around.
I'm going to wish you the best of luck with that.
Thank you.
I don't like to hold people in jail. I didn't really have any choice in your matter. You failed to appear 6 different times.
I know, I do understand that.
I'm going to follow the recommendation, 364 suspended. I'm not going to impose any fine. I'm going to, I'm hoping any resources you have that you're allowed, you can devote those towards bettering your life.
Thank you.
That we've discussed before, but I'm going to wish you the best of luck. You take care. You're going to be released on this matter. And I'm going to wish you the best of luck.
Thank you.
Future is pretty much up to you. I'm hoping that you're real serious about the getting into treatment and getting things turned around.
Thank you so much.
Good luck.
Thank you, Your Honor. And Your Honor, back again here, this is Christina Russell, and she's got 3 matters on for court this morning. All on for arraignment. I've gone over with her, what an arraignment is, and she'd like to waive that and proceed, and we've talked about the matters, so I believe it's gonna be our intention to enter a plea to one of the counts of criminal trespass. And then a plea to one count of the possession of controlled substance. City, as part of the agreement, would then be moving to dismiss the other criminal trespass case. And the recommendation is it's gonna be time served, and I don't believe the city was asking for any financial obligations.
Morning, ma'am. I'm appointing Mr. Haverco to represent you in this matter. Is your full name Christina Renee Russell?
Yeah.
Ms. Russell, I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, and one count of knowing possession of a controlled substance. Have you gone over the plea form with Mr. Haverco? Have you gone over the plea form and the process with Mr. Haverco?
You need to answer all that.
Yes.
And if you had any questions about what it meant to enter a plea of guilty to a criminal matter, was any question you had answered?
Yes.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentence, which could be up to 90 days in jail and or $1,000 fine on criminal trespass, and 180 days and or a $1,000 fine on knowing possession of a controlled substance. You realize that?
Yes.
With that in mind, as to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on March 21st, 2025, and one count of controlled substance, knowing possession of the same, alleged to have occurred on the same date, February 21st, 2025. How do you plead guilty or not guilty to those two charges?
Guilty.
Did you make those pleas of your own free will?
Yes, of course.
Anybody make any threats or promises?
No,
to you?
sir.
You plead guilty.
I do. I would.
I'll find the pleas to be freely, knowingly, and voluntarily made. And your statements in paragraph 11 do satisfy the factual elements. I'll turn to Mr. Haverco for the recommendation as to sentence.
Oh, thank you, Your Honor. Just the city's recommendation was just credit for time served. They weren't asking for any financial obligations. So the intention, I think, was to allow her to be released today. I think she may have a warrant out of Olympia Municipal Court. Don't know, whether or not they're gonna get her or not. Otherwise, I would anticipate she'll just be released. So that's what we're asking, Judge.
Mr. Ratfield, anything to add? No. Mr. Russell, you have a right to tell me anything you want to regarding the matter. You don't have to say anything, but if you want me to know anything about the situation you're in, now's the time.
I'd rather not, thank you, sir.
Ms. Russell, I don't like to hold people in jail. That's the problem is that was the only way I could get you to address the matter. You simply would not appear for court when ordered to. I'm going to follow the recommendation, 90 days suspended on criminal trespass second degree, 180 days suspended on possession of a controlled substance. I'm not going to impose any fine, jail time suspended on the condition you have law-abiding behavior. That especially applies to knowing possession of controlled substances. You'll be released on these charges today, and whether you're held on any of the other matters you have in other courts, that's going to depend on the other courts. Any questions you have of me?
No, sir.
Hey, thank you, Ms. Russell. You take care of yourself. Best of
Yeah,
luck.
I appreciate it, sir.
Hey, thank you, Judge.
We'll see you before too long.
Okay.
Go to the 10 o'clock calendar, docket number 6, Jose Antonio Arapan Barrera.
I have to do, I guess, a quickie.
Oh, that's, oh, Donnie can teach how to do that. Apparently O Courts is, not very helpful this morning.
Okay, so oh, okay, cool. So this is who? The plan of, okay, gotcha. Give me a second here. Okay. So I think we're ready to proceed on Mr. Jose Antonio. Ipane Barrera. And are we on the record?
We are in record.
Yeah, okay, so if I could just add, so the matter comes before the court for a pretrial hearing on a DUI for driving under the influence charge. I've had an opportunity to discuss the case with the defendant, with the assistance of the court certified interpreter.
And Mr. was put under oath earlier,
Sorry.
and is still under oath.
And I believe the parties have reached an agreement. That being what we call a slow neg, the matter to be disposed of by way of a stipulated order of continuance. The matter to be continued for 2 years on the usual DUI related conditions. At the end of which time, if he complies, the city would then move to amend to negligent driving in the first degree. It's the case is continued for 2 years. And at the end of 2 years, if he complies with the condition. I added some additional explanation for the defendant with the assistance of the interpreter. I believe I've answered those questions.
Okay. Good morning, sir. For the record, is your full name Jose Antonio Arapan Barrera? I'm looking at an agreement between yourself and the city negotiated by Mr. Haverco. Over the next 2 years, if you abide by the conditions, the charge will be reduced from DUI to negligent driving in the first degree, which is a much less serious charge. You're agreeing that you will have no criminal law violations and you will obtain a drug and alcohol evaluation within the next 90 days and then comply with any conditions and recommendations made in the evaluation. The costs are $990.50, which you can pay at the rate of $50 a month. Now, this is a very good agreement, but if you violate it, we'll have a hearing based on the police reports. Because you've given up your right to go to trial and all the rights associated with that. Any questions of me? Whether he can drive or not depends on the Department of Licensing. I cannot suspend your license. All I can do is advise you, don't drive unless you're licensed and insured. And the Department of Licensing is the one that controls that. Any other questions? I'm going to wish you the best of luck. What I want you to do is get a copy of the agreement at the window outside the courtroom. And if you have any question about what it means, get a hold of Mr. Havercove through Mr. Mold. I'm going to wish you the best of luck. Take care of yourself.
Okay, so the next matter, I believe, would be Arnold David Ramirez Polito.
Good morning, sir. Full name, Arnold David Ramirez Polito. Matter set for pretrial. I'll defer to your attorney for the status of the matter.
Thank you, Your Honor. I had an opportunity to discuss this case with the defendant with the assistance of the court interpreter. And we discussed the elements of both charges and his rights and everything legally connected with the case. I believe we have a resolution, which is, I believe he intends on entering a straight plea to count 2, driving without an ignition interlock device as ordered. In exchange for the plea as part of the plea bargain, city would move to dismiss count 1, the suspended driving 3rd degree. Yes. Yeah.
Good morning again, sir. I'm looking at a statement of defendant on plea of guilty to 1 count of driving a motor vehicle without ignition interlock. There's also a dismissal of driving a license suspended or revoked third degree. If I accept the plea, you give up the rights in paragraph 5. No trial, no appeal, no witnesses, just a sentencing. And that could be up to 364 days in jail and up to a $5,000 fine if I thought appropriate. Have you discussed the matter with Mr. Haverco with the help of the interpreter? Do you have any questions about what it means to enter a plea of guilty? Okay, thank you. As to one count of operating a motor vehicle without ignition interlock within the city of Yelm on January 13, 2025, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made and your statement in paragraph 11 does satisfy the factual elements of the offense. City, have anything to add? Mr. Haverco, anything to add?
Nothing to add, Your Honor.
Mr. Ramirez Polito, you can tell me anything you want, think I should know, want me to know. You don't have to say anything. The recommendation is a fair one.
Just think.
364 days suspended. On conditions of law-abiding behavior, including don't drive unless licensed and insured. $250 fine, which you can pay at over time. Any questions? I will sign a judgment and sentence at this time. What I want you to do is go to the counter and get a copy of today's paperwork. Mr. Mold will help you understand it. And if you have any questions, that's what Mr. Haverco is here for. I'm going to wish you the best of luck. After a while, the ignition interlock requirement drops off. I'm going to wish you the best of luck, sir. Take care.
You got it? Okay. Here, Your Honor.
Mr. Mold, thank you very much. Thank you for your patience. Thank you. Mr. Haverco, on the 9:45 calendar, we have 3 matters, all for arraignment. If you're here for arraignment, I'm going to call you up one at a time. Mr. Haverco will represent you at this time. He'll enter a plea on your behalf, and throughout the course of your matter, should you be and request his services. First would be Brittany Burnt.
Okay.
Full name Brittany Roseanne Burnt, B-E-R-N-D-T. Citation alleges that on or about November 19, 2022, you committed the offense of theft third degree, which is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Appoint Mr. Haverko to enter a plea on your behalf at this time and represent you throughout the course of the matter.
Stipulated probable cause, Your Honor, ask the court to enter not guilty, please.
Plea of not guilty. Plea of not guilty preserves your rights. We're going to set the matter for a pretrial on June 5th, 2025. I want you to make sure Mr. Haverko has your contact information. His contact information will be on today's order. You can get a copy of that at the window outside the courtroom to your left.
Before we leave, they'll print up copies.
Thank you, ma'am. Jari Collins. Good afternoon, sir. Full name Jari Armand Collins. Citation alleges in honor about December 15th of 2024. You committed the offenses of violating an order restricting contact and theft in the third degree. Each of those is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko to represent you. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty, please.
Mr. Collins, plea of not guilty preserves your rights. We're going to set the matter for a pretrial conference. I want you to give Mr. Haverko your contact information, if you would. Pretrial, June 5th, 2025, 11 o'clock.
And then I need it. By three.
Collins, thank you for appearing. Don't forget to get a copy of the order at the window outside. How about Jeremy Crayon? Mr. Crayon, come on up and have a seat if you would. Full name Jeremy Patrick Crayon. Mr. Crayon, the citations I have alleged that on or about March 16th, 2021, you committed the offense of theft in the third degree. Second citation, January 9th, 2025, for the same offense, theft in the third degree. Each of those is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to represent you, and he'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty, please, on both matters.
Again, Mr. Grant, what I want you to do is give Mr. Haverko at this time your contact information. June 5th is your pretrial date.
Can't understand. Okay. All right. All right.
Of course, of course.
Is it
But
Brennan?
once-
B-R-E-N-N?
If they own it. Sorry. Mr. Grant, any questions? You need to be back here on the 5th of June. In the meantime, take care. Stay in touch with Mr. Havico and law-abiding behavior. Take care of yourself. Is Richard Carter here? Richard Carter does not respond. We'll come back to that matter. How about Zach McBride? Mr. McBride, you missed a pretrial earlier. Glad to see you here now. Won't be able to address your matter now. Today, Mr. Havico wouldn't have your file
Yeah, we just
available.
asked. Yeah.
We're simply going to reset the matter. We'll quash the warrant. I want to thank you for appearing. And we're going to give you a notice as to another pretrial date. Any questions at all?
Yeah, let me reconfirm your phone number. Your phone number? Yeah.
Mr. McBride, you'll get a notice of hearing at the window outside the courtroom and to your left. May 22nd is at 11 o'clock in the morning is the next court date, but that'll be on the notice you can get at the window outside the courtroom and to your left. Good luck, sir.
Thank you, Your Honor.
Thank you, sir. And that brings us back to brings us to the pretrial calendars.
Oh, okay. Is Adam Cass here? Okay, why don't you come on up? How you doing? Good.
Morning, sir. Is your full name Adam, middle initial L, Cass?
Yeah.
I'll defer to your attorney for the status of the matter.
One moment. Your Honor. Go and sign here. It is, yeah. So this is Adam Cass. Matter comes on for a pretrial hearing on the charge of suspended driving third degree and ignition interlock device violation. Parties have reached an agreement. He's going to enter a straight plea to count 2 interlock violation. Upon the court's acceptance of the plea, city will move to dismiss count 1, the suspended driving charge. Recommendation is just all suspended jail time, suspended for 1 year on the condition you have no new criminal law violations and pay a $250 per fee.
Mr. Cass, do you disagree with anything Mr. Havico just said? I'm looking at a statement of defendant on plea of guilty to 1 count of operating a motor vehicle without ignition interlock, referencing a dismissal of the DWS third charge, which I'll do if I accept the plea. The charge you're pleading guilty to is a gross misdemeanor. The maximum penalty would be up to 364 days in jail and or a $5,000 fine, which I would be free to impose if I saw fit to do so. You realize that. And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing from which there wouldn't be any appeal. You realize that. With that in mind, as to 1 count of operating a motor vehicle without ignition interlock within the city of Yelm on March 2nd, 2025, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. I've heard the recommendation phrased by Mr. Havico. Mr. Hatfield, anything to add to that? Mr. Havico, anything to add?
Nothing to add, Your Honor. Just ask the court to follow the recommendation.
Mr. Cass, anything you'd like me to know? Now's the time. You don't have to say anything. I'm going to follow the recommendation. A year in jail, all suspended, a year less 1 day in jail, all suspended on the condition you simply have law-abiding behavior, pay a $250 fine. The fine is less very unimportant to me. If you have difficulty making the payments, let us know, okay? These are requirements that drop off after a while. What I'm hoping is you'll complete whatever period of ignition interlock the Department of Licensing wants, and then you go forth and have a perfect driving record and not be bothered by the Department of Licensing or any court again. Any questions at all? I want to thank you for appearing, Mr. Cass, and thank you for your patience. You take care. I want you to get a copy of today's, I'm citing the judgment and sentence at this time, electronically, of course. I want you to get a copy of today's paperwork at the window. Look it over carefully. If you have any questions at all, give Mr. Haverco a call, okay? Good luck to you. And thank you.
Sir, Maria, Adam here. Sir Timothy Higgins. Oh, okay. Let's see. Is there a Levi Key here?
Full name Levi Shane.
Yes, sir.
Okay.
Parties wish to reset the matter a couple of weeks. It may result in an amendment to an infraction.
May 22nd
Sure.
would be the next court date.
Sure.
Mr. Keith will simply give you a notice to that effect. Keith, notice of a hearing, you'll be able to get that at the window outside the courtroom to your left. Go ahead and get that
Let's
before
go
you
ahead and
leave.
sign right here. Yes. Yep, that's good. Yeah, you just pick up. Yeah, just pick up.
Mr. Keith, thank you for your patience. We'll see you here in a couple of weeks.
Is Jacoby Kane here? Jacoby Kane? Okay. What about Melissa Miller?
Good afternoon, ma'am. Full name, Melissa Ann Miller. Defer to your attorney, matter set for a pretrial. I'm looking at a statement of defendant on plea of guilty in Old Courts, Mr. Haverco. I'll
Yeah, I'm gonna
defer to you.
ask her to sign that. Go ahead and sign it. Yeah, so this is Ms. Melissa Millen. Matter comes before the court for a pretrial hearing on a theft charge. Had an opportunity to discuss the matter with her, and the parties have reached an agreement. She intends on entering a straight plea to the charge. And then would want to be heard as to, I can just say it now. City customarily just recommends a court fee, and we're asking the court to waive that. She has a pending L&I claim, and she's not working, and asking the court not to impose any cost.
That's it. We'll get to that.
Yeah.
That's it. Ms. Millen, I'm looking at a statement of defendant on plea of guilty in the Old Court system. Tells me your age is 43, been through the 12th grade in school. Any difficulty at all reading, understanding the plea process? The plea represented in the statement is to one offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty would be 364 days in jail and or a $5,000 fine. I'd be free to impose that if I saw fit to do so, regardless of what's recommended. You realize it. And if I accept the plea, you're giving up the rights contained in paragraph 5, no trial, no appeal, just that sentencing of which I spoke. Any questions of me regarding the process? With that in mind, as to theft in the third degree alleged to have occurred within the city of Yelm on March 9th, 2025, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? Pardon?
I said my husband, but I don't think he counts. No, he didn't. Joking.
I'll find the plea to be, well, anybody make any threats or
No.
promises to you to make you plead guilty? You made the plea of your own free will. Your statement in paragraph 11 satisfies the elements. I'll accept the plea as made. Mr. Travico, anything further?
Nothing to add, Your Honor.
Mr. Ratfield, anything further? Ms. Miller, anything you want me to know about yourself? I've heard what your attorney said about the financial.
Yeah.
To follow the recommendation, all jail time suspended on the condition you have law-abiding behavior. I'm not going to impose a fine, but keep in mind, how would you feel if somebody walked off with something that was important to you or something you owned? You wouldn't be very happy about that. The law basically boils down to two things. Don't disturb other people, and hey, don't disturb other people's property. That's about it. That covers just about everything. I'm going to wish you the best of luck. Hopefully this has been something of a learning experience. It's going to take me a moment to sign the judgment and sentence. I'm doing that as we speak. What I want you to do is get a copy of today's paperwork at the window outside and to your left. Look it over carefully. And if you have any questions that come to mind, give Mr. Travico a call. Any questions of me? Good luck to you, and thank you for your patience. You take care. Have a good day.
Not sure how to pronounce the last name. Is there Yelm? Oh, I know you're here. Okay.
I think John Smith would be next.
Yeah, we can take John Smith.
Is John Smith in the courtroom?
Give me just one.
Mr. Ratfield, you may recall this matter. It's on for compliance with the diversion. There was an SOC entered on February 1st, 2024. And the defendant has had a year to comply with the terms. And there's been no proof of moral recognition therapy and no proof of alcohol and drug information school.
So I think we're ready to proceed. This is, I reviewed the docket and just discussed with Mr. Smith the situation. It's essentially failure to comply with failing to do stuff. And it was ordered some time ago, I think probably around a year ago or so. And so, as is not often the case, it's kind of an issue of money and time. Well, not really so much time, but it's mostly kind of money and transportation. He lives out, kind of in a remote area, can't drive. He's indicated to me that, did you say it was your brother or did he? Yeah, brother-in-law. Oh, brother-in-law. So he's indicated to me that his brother-in-law has apparently offered to, provide transportation to, treatment provider. And so, it's still like time to, it's still like an opportunity to try to comply.
We have had a number of hearings. Mr. Smith has promised to see it, and that just hasn't done. It's an agreement between Mr. Smith and the city. I'll turn return to the city. The violations are self-proving. That's, all I have to do is look at the file.
Yeah, Your Honor, well, you know, transportation, being offered by a family member is great, but ultimately, you know, the burden still falls on Mr. Smith, and it just seemed like a little too little too late at this point. The city is still seeking revocation on the matter, and like Your Honor to review the report.
I really don't have much of a choice. Mr. Smith, I am going to revoke the SOC, and based on the reports on file, I will enter a finding of guilt as to one count of DUI, no test results. Given the lapse of time, this goes back to 2022. I'm not interested in much in the way of a sentence. I'll sentence you to I just want the finding of guilty to be of record. 364 days in jail, suspended on the condition you have law-abiding behavior, is going to be the sentence of the court, unless the city is asking for anything
No,
further.
no, Your Honor.
I'm doing that based on the lapse of time. Do we need any paper? Oh, boy. City wish to do anything? The fine hasn't been paid either, but that's.
You know, do you just reimpose the fine and the order? I mean, I don't know if the court can, I don't know if the court has any authority to waive the fine.
There's been discussion on that, springboarded by all the discussion about indigency, et cetera, et cetera, et cetera. You know, I really, on the one hand, I don't have any authority to waive any fine, but what am I going to do? I can order the payment of fine, and I'm going to order the payment of a fine, and at the appropriate time, if it's not paid, it'll be referred to collections, and that may or may not mean anything to Mr. Smith. Mr. Smith, the only thing I'm really concerned about here is any reoffense. The point of the ADIS, the required, the point of that is to make sure as best we can is there wasn't a reoffense, and that apparently that never worked out. But the jail time is there, and it's suspended, and if there's any violation, I would be inclined to impose some jail time. So you have that to be concerned with. Any questions at all? All I can do is wish you that concludes the matter as far as I'm concerned. There isn't any debtor's prison to throw you into if you don't pay a fine. There's really nothing I can do. And it'd be kind of fruitless to order, as I am supposed to do, eval and treatment, because you haven't done it since 2022, and I don't see that happening in the future. That I'm not going to say you up for failure. All I'm going to do is wish you the best of luck and conclude the matter.
You don't have. You revoke the deal. Okay.
Beth, I wish you the best of luck. Take care. You're excused.
I just want to kind of take a little extra roll here since we're after 11 o'clock to see.
Would you like me to do that?
Yeah, I'll need to do it.
Morning, sir. Full name Nathan Paul, Michaelis. And it is Michaelis, isn't it? Yeah. I know people of the same name, but it's pronounced Michaels, but sorry if I slip, it's unintentional.
Give me one moment, Your Honor.
I am looking at the filings and I've reviewed before court, the filings,
Just need to get
and I'll
some
defer to Mr.
signatures here
Haverhill.
on finally. That's good. And then I have one more for you. Does the court have the evaluation? I don't know if the court does. I have a copy, if you don't. We've submitted into, the court may have a copy. I don't. Handing forth your honor. Proposed petition or finding in full court's pre-review.
In just a moment, these evals, there's a lot of boilerplate in them, but I can get the crux of it fairly quickly, but I need a moment to.
Yeah, just make sure that the court. It's approved. Okay.
Mr. Michaels, the recommendation as to treatment is fairly standard and what I would have expected to. Let me say this. I look at what would happen if you entered a plea, just pled guilty. and what would happen if you got into a deferred prosecution. You've chosen the harder road to walk here. This is quite a, didn't always be that way, but at the present time, a deferred prosecution is quite a load to carry. That's there's treatment recommendations, the driving recommendations, and the last thing in your petition states and acknowledges the court will dismiss the charges against me, in this case, 3 years from the end of the 2-year program. This is a 5-year shot here. But you've got to successfully complete the treatment. Have you started it yet? Has it improved your life at all? I hear that a lot. You know, I'm sleeping better. I'm feeling better. I have more money to spend. All the above. It's and a lot of people wish they'd maybe gotten on the issue in the past. But hey, you're here now, and you're doing what you need to do. I'm going to approve of the deferred prosecution program. There's recommended costs in the amount of $500, Mr. Aberco.
Yeah, I believe it's built into the form.
It is. That's you can pay that over time. That's the least important thing to me here. If you have issues making the fine payments, let us know, and we're going to deal with that. All I can do is wish you the best of luck. The road to sobriety to recovery is not a smooth one, and it's not without its speed bumps and ups and downs. Just stay with it. It's not how many times you fall down, it's how many times you get back up. That's the important thing. And sometimes, hey, some people, they have a DUI and they wake up in the hospital, or they wake up in a jail cell having killed somebody else out there. I've seen that a number of times over the years I've been in the legal profession. And so in a way, you're lucky. You're here, you're healthy, you haven't hurt anybody, you haven't hurt yourself. And you've identified an issue in your life that you can do something about, and that's exactly what you're doing. My hat's off to you for that. Signing the order, the findings of fact. What I want you to do is get a copy of the formal petition. A lot of boilerplate in it, but you get that at the window. I want you to go over it just to make sure you know what you're doing. I think you already got a really good handle on it. Mr. Michaelis, I'm going to wish you the best of luck. You take care of yourself, and again, yeah, the important thing is stick with it. Stick with it. Not every day is a smooth one, but we get through the days. You say the day passes slowly, the years just fly by. You take care of yourself.
Take care. Take care. Have a good day.
And you as well.
Hey, Jeremy, come on. Yep.
Is this Mr. Heikela?
It sure is. So this is Mr. Jeremy Heikela. Matter comes before the court for pretrial hearing on a protection order violation. He's going to enter a plea to the charge. We place that in O courts.
Morning, sir. Full name, Jeremy, middle initial C, Heikela.
Yeah.
Mr. Heikela, you disagree with anything Mr. Havercoat just said? I am looking at a statement of defendant on plea of guilty to one count of violating the terms and conditions of a protection order. Tells me you're 48 years of age. Any issues at all reading, understanding the plea process? And you've gone over the process with Mr. Havercoat, and he may have he's answered any question you might have.
Yeah.
Anything you'd like to ask me about the process?
Yeah, at the moment, no.
If I accept the plea, This being a gross misdemeanor, the maximum penalty would be 364 days in jail and or a $5,000 fine. I'd be free to impose that if I saw fit to do so, regardless of what's recommended. You realize that. And if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, just simply a sentencing, and that resolves the matter. With that in mind, as to one count of violating the terms and conditions of a protection order within the city of Yelm, how do you plead guilty or not guilty? You make that plea of your own free will.
Yeah.
Anybody make any threats or promises to you to make you plead guilty?
No.
Date of violation of March 11th, 2025. You make the plea of guilty of your own free will? Anybody make any threats,
No.
promises to make you plead?
No.
Plea was freely, voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Haverko, anything to add?
Nothing to add, Your Honor.
Mr. Ratfield, anything to add?
Nothing to add.
Mr.
Your Honor.
Eichelin, anything you'd like to tell me or want you to? Yeah, these no contact orders, they're carved in stone that no matter how permissive any contact is, they mean a lot. You can't violate them unless they're modified until they're modified by a court. I'm going to follow the recommendation, $250 probation fee, 364 days, suspended on the condition you have law-abiding behavior. Stay out of trouble, abide by any and all no contact orders in effect. Any question about anything I've just said? I'm going to wish you the best of luck. I'm signing a judgment and sentence to the effect of the ruling. What I want you to do is go to the window outside the courtroom to your left, get a copy of today's paperwork, review it, and if you have any questions about what it says or means, give Mr. Haverko a call, okay? Mr. Eichelin, good luck to you.
You too.
Take care.
Take care, Jeremy. Georgia? So this is Georgia Leitz. She has two matters, both of which come before the court for pretrial hearing. One is a criminal trespass first-degree case. Other is a criminal trespass secondary case. Parties have reached an agreement. She's going to enter a straight plea to the case ending in 287, criminal trespass second degree. Upon the court's acceptance of that plea, the city would move to dismiss the criminal trespass first degree case ending in 286, and then we'd like to address the issue of any costs.
Good afternoon, ma'am. Is your full name Georgia Rosalie Leitz? There's a way to mispronounce a name. I'm going to stumble across it. Do you disagree with anything Mr. Haverko just said? I am looking at the statement of defendant on plea of guilty to one count of criminal trespass second degree, referencing a dismissal of criminal trespass first degree. The difference is this: second degree is a simple misdemeanor. The maximum penalty and conviction would be 90 days in jail instead of a year less a day, and a $1,000 fine other than a $5,000 fine. I'd be free to impose the maximum regardless of what's recommended. You realize that. And if I accept your plea, you've given up the rights in paragraph 5, no trial, no appeal, simply the sentencing that I referenced. With that in mind, as to one count of criminal trespass second degree, alleged to have occurred within the city of Yelm on November 4th, 2022, how do you plead guilty or not guilty? Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is 90 days, all suspended on the condition you have law-abiding behavior and pay a $250 fee. I'll turn to Mr. Haverco with regard to that recommendation.
Thank you, Your Honor. Would ask the court to consider waiving that fee. She and I had a discussion about this. She had done time in federal prison, and she's currently living in a federally operated halfway house, doing the completion of her federal time probation, and so she's now on 3 years of federal court probation, and so, you know, I'm assuming with all of her various mountains of fines, and she's not yet working, you know, just ask the court to not impose any additional costs.
Mr. Radfield, anything to
No
input?
comments.
Ms. Leach, you have a right to tell me anything. Well, you don't have to say anything, but if you want me to know something about your situation, now's the time.
I'll pass.
You'll pass. Okay, don't blame you. It's sometimes lawyers are known to tell their client, and I know I have many times, being where Mr. Haverco is, you might say you have a right to say something, but there's nothing you can say that'll help you, and a lot you can say that'll hurt you. So that was, but yeah, if somebody has something to say, I'm always interested in hearing it. It sounds like you're digging yourself out of quite a hole in life, but you look well, you look healthy, and I'm going to follow the recommendation in part. I'll impose the jail time, 90 days, but suspend it all on the condition you have law-abiding behavior. I'm not going to impose any monetary penalty. If the feds have their clause in you, that's enough. They can have a heck of a lot more to do than I can. Any state court can ever. I'm going to wish you the best of luck. It looks like you're on a good path now. Stay with it. Stay with it. Don't give up. I'm comfortable that everything is going to be okay. Just look at your demeanor. Any questions at all? I'm going to sign an order as soon as O Courts lets me do that. And that's sometimes. I'm not sure what happened. Now, I have signed the judgment and sentence. Besides, get a copy of it as I indicated. Look it over carefully. Give Mr. Haverco a call if you have any questions. And again, I wish you the best of luck. You take care of yourself. That's it.
Good luck.
Thank you, ma'am.
Sharon? Yeah, sure. So this is Sharon Pluskett on the 11 o'clock calendar. Matter comes on for pretrial for a DUI charge. Parties have reached an agreement. It's a long, slow, reckless 5 years, and right. And the basis of that is the city and I discussed it, and it had to do with the fact she has a prior DUI. It's quite old, but it was amended, but that affected, you know, negotiations, and so this is where we are. And it's still more beneficial than pleading guilty to a DUI. Yeah. It's 5 years. Correct. So what I was trying to explain to you is that if you get an evaluation, okay. Yeah, and by the way, just for the record, I did discuss all options with Ms. Pluskett. We talked about deferred prosecution, and that was a possibility. And one of her reasons, I think, for electing to do this was that the deferred prosecution is a 2-year treatment program. It's a little more costly. This is not deferred. It won't get dismissed, but it'll get amended, and it's likely the treatment will be short of what a deferred prosecution treatment program would be. So not a perfect solution either way, but this is what we decided.
Good afternoon, ma'am.
Yes.
Full name Sharon Jane Pluskett. Is your full name Sharon Jane Pluskett? Ms. Pluskett, I've heard people say, you know, these SOCs are too good of a deal. Or in my opinion, they're a great deal because if you do what you're supposed to do in the agreement and you get the benefit of the bargain, we've succeeded. And if you don't succeed, if you violate the agreement, we've got a conviction without having to go to trial. That's the city's, but never say never, but yeah, that was, devote yourself to that. All you can do is the best you can. The SOC is, as Mr. Havergal has indicated, it's an agreement to, under the terms of which you're gonna get a good result. 5 years, 60 months down the road, charge will be reduced to a much less serious charge of reckless driving. That's still a hit, but much less than a DUI. Now, what you're agreeing is that you'll pay a probation fee of $990.50. You won't have any criminal law violations, especially when it comes to drinking and driving. And you'll get a drug and alcohol evaluation within the next 90 days and comply with any recommended treatment. Hopefully that'll go well with you. Now, if you violate this agreement you have and the city proves that, we'll have a hearing based on the police reports, and that'd almost certainly result in a conviction for DUI, and that triggers, as you know, all kinds of unpleasant things. If you successfully complete the 5 years, you won't have to come back here. But I want you to make sure you keep a good address on file, just in case there's a problem or the city alleges something, we can get you notice, okay? But again, all I can do is wish you the best of luck. Make sure that we know where you are, and have on file here a drug and alcohol evaluation within the next 90 days.
And if they find out I don't have any issues, then I can.
Absolutely, absolutely. They may recommend you, they may find you have no significant problem, might recommend a victim impact panel, drug and alcohol information school, which is 8 hours of education. Just have to wait and see what they say. And I've often thought that the evaluating agency shouldn't be the treating agency, because it too much of a temptation, I think, sometimes for an agency to say, you need our $5,000 treatment instead of our $200 tune-up. But that's just not the way it works. You are entitled to second opinions on that.
So if I don't feel like it was the right size.
If you disagree with them, talk to them about it, and you're entitled to go to another state certified agency. But they have to realize, they have to know what the earlier agency said. Well, that's pretty easy. You can ask for a list at the counter, and there's all kinds of them.
Thank you.
Ms. Pluskett, I'm going to wish you the best of luck. You take care of yourself. I can't do any more than that. I look forward to this charge being dismissed at the end of the time.
Well, it won't be dismissed. It'll be amended to reckless.
I'm sorry.
Yeah.
I'm sorry. It's amendment to reckless. Sometimes I'm not thinking as fast as I'm talking, but I'll try and remedy that. Ms. Pluskett, good luck to you. Take care of yourself. That's when you go to the, oh yeah, yes, you can. It'll be out at the counter with the, Ms. Pluskett, I really mean this. Good luck. You take care of yourself. I will. And thank you.
Tanner, why don't you come up? Go inside here. Talk more. Sign. Okay, this is,
Tanner Watson.
Tanner Watson and matter.
Mr. Watson, good morning.
Matter comes before the court for a physical control case. Placed a motion to continue with a speedy trial waiver into Oak Courts, asking to reset, kind of in the ordinary course.
I guess it's up to you.
Sure.
June 5th, 11 o'clock in the morning.
Really?
Mr. Watson, I'm signing an order to that effect. In the meantime, stay in touch with Mr. Haverco. Any conditions of release earlier set remain in effect. And be back here on June 5th. Any questions at all? The order of reset will be at the window outside the courtroom and to your left. Mr. Watson, thank you for your patience.
Ms. Weston Haber? Hello. This is your motion to continue. This is Jennifer Weston Haber, matter comes on the court for the court for pretrial hearing on violation of harassment order, no contact order. Have placed a motion to continue in Oak Courts, along with a speedy trial waiver, asking to set in the ordinary court.
Is it Jennifer Jean Weston? Ms. Weston Haber, we're going to reset the matter to a future court date at the request of yourself and your attorney. In the meantime, yeah, June 5th, 11 o'clock. Meantime, stay in touch with Mr. Haverco and
She has a pretrial on June 5th in the Thurston County Courthouse. Maybe we could kick it out another 2 weeks. Is that possible?
well, I haven't signed it yet. Hold up. If I can back out, I will.
Okay.
I've left.
Okay, good. One of the public defenders. Okay. Good.
June 16th. Now that is that's a Monday, not a Thursday. Mr. Weston Haber, I'm citing the order. I want you to get a copy of it at the window outside the courtroom to your left. And again, stay in touch with Mr. Haverco. We'll see you back here in June.
Mhm. Well, that's just an issue for impeachment. Not a conflict. That's a fight. That could be brought out for. Feel like there's no legal principle that says he's got some cost to it. Yeah, let's just wait. Let's see what happens. Are we done? Oh, you're free to go.
We're done.
Yeah.
Yeah, don't forget to get the order at the window.
David Hernandez? David Hernandez. This is David Hernandez. Matter comes before the court for a pretrial hearing on assault fourth degree domestic violence. It's my understanding the city has a motion on this case.
Yes, Your Honor, city.
And there's an order of dismissal. Mr. Hernandez, I note the order is without prejudice. What that means is the city could reconsider, discover new evidence, rethink the matter and refile the matter if they choose. I don't see that happening, but once in a blue moon. So I'm sure, hearing no objection to the dismissal of the charge, I'm signing the order as we speak. Good idea to make sure that Mr. Haverco has any change in address, just in case the city decides to refile. That concludes the matter. You're free to leave. I signed the order. If you want a copy of the order, you can get that at the window outside the courtroom to your left. And good luck with your situation.
And did we have someone on Zoom?
Mr. Higgins is
Oh.
on,
Okay.
and we have somebody who's waiting in the courtroom as well.
Right, I need to chat with
Oh,
Ms.
okay.
Zarate, or so just whenever we.
Sure, I'll defer to you, whatever you want
Well,
to do. If you want
do you want
to,
to, you want to get rid of Mr. Higgins first, or? Well, I mean, Higgins is just like this, Higgins is a case where, I mean, I'll just go on record and, I haven't had any contact. I tried to call, no answer. I've had no contact.
let's go on. Let's go on with Mr. Higgins. Bring him
Yeah.
up. That shouldn't take too long. Mr. Higgins, I can see you're present. Are you unmuted? Are you able to hear me?
There we go. Yeah, just had to reload real quick.
Mr. Higgins is present. Are you able to hear me, Mr. Higgins?
Yes, Your Honor.
Mr. Haverco is in the courtroom. You're here for a couple of pre-trials and also a sentence compliance hearing. I'll defer to your attorney for the status of the matter.
I'm not prepared today.
Yeah, I was gonna say, did you get my number when I updated it last time?
I have a number that ends in 0868.
No. It should be a 9020.
Don't have it. I'll need to, what is your new number?
360
Okay.
689
Okay,
9020
90 what?
020.
9020. Okay, so just, I haven't had any contact with Mr. Higgins. Therefore I don't have a disposition of any kind. I need to speak with him about these cases, resolve them. I now have noted his updated phone number, and I'll make a note of that in my records. I would ask to reset all matters, so that I have an opportunity to talk to him.
Do you have any input?
No.
Mr. Higgins, you need to, I think, keep better contact with Mr. Haverco.
Yeah, I had updated it last time. We had court on the 24th, I believe it was. I'm not sure why he still had the 0868, but I did update it with the email that I'd gotten.
It's a two-way street. I won't say any more than that. There's also a concern with the treatment indicated in the prior matter going back to February in 2022. That was be the reckless endangerment charge. We'll address that matter next hearing as well.
Okay, yeah, I was gonna say I've got a completion form that I just haven't submitted yet.
Yeah, we'll need that.
Okay.
Next hearing will be May 22nd. Mr. Higgins, if we have a mailing address for you, we'll be sending you a copy of that on May 22nd. I'll expect you to be here.
Okay. I'll do my best. Ted's been in the hospital.
Pardon?
Ted's been in the hospital for a couple of days now. Mr. Wilkinson, and then we've got.
It's something Mr. Haverco should know about, definitely. But be in touch.
Yeah.
And that should be probably later today, I'm going to guess. But
yeah. When I talk to him, I'll let him know more.
We'll send to the last known address that we have for you. We'll send you a notice of the new hearing. Okay.
Is the address 16506?
16506.
Yeah.
That's the address we have. That's where,
All right.
that's where the notice will go. Mr.
All right. Thank you.
Green will address the matters again on May 22nd.
Thank you.
See you then. Maria Teresa Zarate. Now on record, Yelm versus Maria Teresa Zarate. Mr. Haverko?
Thank you, Your Honor. She has two matters, both of which come on before the court today for a pretrial hearing. One is suspended second degree charge, one a controlled substance violation charge. Asking to reset. I mean, I'll just reveal our strategy. We're trying to limp our way out to 6 months. For the thing on her record that's holding her up is going to be lifted in November. So my suggestion is, if we want to still see her in their intervening time, is reset the matter for 3 months, you know, and then just make sure she's not having any new criminal law violations. And we may ask for one more reset after that. If her, you know, suspended status winds up being reduced down to third degree, that'll be of great benefit to her. So
That's a good idea. How about we go out to Mr. Ratfield, any objection to going out to say August 28th? Does that work?
Don't drive, don't drive. Just, okay.
August 28th, what we want to do is see you get relicensed, you know,
Exactly.
we'd like, you know, and I will do anything I can to accommodate your request. Let that happen. Can set it up to August 28th. I'm signing the reset as we speak. What I want you to do is go to the window, get a copy of the, it'll have the date. August is down the road a little bit, so I want you to keep a note on the refrigerator, whatever you do, to make sure you're here.
Put it in your phone or something.
Ms. Roddy, that concludes the matter. Good luck to you. Take care. We'll see you back here at the end of August.
Okay.
Thank you, ma'am.
Okay.
Thank you, ma'am. No problem. Thank you.
Ms. Nguyen?
Is this Michelle Nguyen?
It is. Matter, this is Michelle Antoinette Nguyen. Matter comes before the court for a pretrial hearing on a theft charge. I've had an opportunity to discuss the case, review the police reports with Ms. Nguyen. I believe we have a resolution. It's her intention on entering a straight plea of guilty to the charge, and we have a statement of intent on plead guilty in oath court.
Good afternoon, ma'am. Is your full name Michelle Antoinette Nguyen?
Yes.
How do you pronounce your last name? I'm looking at a statement of defendant on plea of guilty to one count of theft in the third degree. Theft in the third degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'd be free to accept that if I accept the plea. You realize that. Also, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which, as I say, could be up to the maximum if I saw fit to do so. Plea form tells me you're 40 years of age. You've been through the 9th grade. Any problem at all going through the plea process with Mr. Averco? Did he answer any questions you might have regarding the matter? With that in mind, as to one count of theft in the third degree alleged to have occurred within the city of Yelm on January 25th, 2025, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is all jail time, 364 days in jail suspended. On, of course, the conditions, you have law-abiding behavior. And is there a recommendation as to a fine?
Yeah, city is recommending the
$250
probation fee, and
probation
we
fee.
don't have an objection to that.
Mr. Hatfield, anything to add to the recommendation? Mr. Haverko?
Nothing to add, Your Honor.
Ms. Nguyen, you have a right to tell me anything you wish. You don't have to say anything, but there's anything you'd like to tell me, now's the time. That's, I've tried myself to learn when I don't have anything to say, don't say anything. I'm gonna follow the recommendation. All jail time suspended, 364 suspended on the condition you have law-abiding behavior, $250 fine, probation fee, 25 a month on that. That's the least of our concerns here. If you have an issue making the fine payments, let us know and we can certainly address that. We can certainly deal with that. Hopefully this has been a learning experience and not one to be repeated. Any questions at all? Now, I'll sign a judgment and sentence to that effect. I'm looking at it now. I want you to get a copy of today's paperwork at the window outside the courtroom and to your left. Look it over carefully. And again, if you have any questions at all about anything you read, give Mr. Haverco a call. Ms. Nolan, thank you. You take care of yourself. And thank you for your patience. It's been kind of a long day for you here. Good luck to you. Take care. And I guess that brings us to the
No-shows?
the no-shows.
On Maria Haddow, I was given a phone number, probably from her arraignment, and called the number and just left a message to call me back. I never got a return call, so I don't have any information for her non-appearance.
1,000 cash or bond. That's Maria Rose Haddow, docket number 2, page 9. Next, how about Mr. King? I have something.
Yeah, I had an SOC.
Yeah.
In Oak Courts, I talked to the guy and, it's a really old case. Thought I had something worked out.
2017, yeah.
Yeah, the guy hasn't reached out to me in the meantime, so he hasn't provided me any additional information, so I have no information as to his non-appearance.
You have heard from him, have talked to him about the matter.
I talked to him, back, talked to him on the 18th. I had a number, and so that's, we were gonna do an SOC and,
Any objection, yeah, over 1,000 cash or bond.
on Tipton, my notes just reflect, I had a number. I called the number appears to be good. So I did actually sometimes you call and they don't connect or they're disconnected. So it appeared to be a good number. I left a message with my phone number. Haven't had any return contact from the guy. So I haven't heard back from him at all. Have no information.
2 compliance matters, 1 arraignment, or 1 pretrial on the theft third. 1,000 each charge.
Yeah.
It's I think that's
Maria.
probably best to preserve any, jurisdictional issues. It's
And Maria Falsetta on the 11 o'clock loaded pistol in car, had a number, called it. I made a note to myself, it sounded good. I put a question mark just because it may have had to do with the sound of the outgoing message. So, but the number worked anyway, and I left a message and have not received any return contact.
so ordered. How about David Hernandez?
That was dismissed.
That was dismissed. I'm sorry. I didn't.
Yeah, and then,
Now I see that.
and then Joshua Patterson, I also had a number for him, and it must have gone through because my note says I left a message to call me back. I never got any return call.
To go back to Michael's, I see there's that, did we address, we didn't.
We didn't,
address
and
the-
I would ask if the city's
Dismiss.
willing, just dismiss it.
Let's dismiss that.
Infraction. We forgot
Dismiss
to
it.
address it. Yeah, thanks for.
Dismiss docket number 7. And Patterson. Garrett, want a warrant on that?
Yeah, let's go down.
So ordered, cash or bond.
And Arthur Saxton had a phone number, called it, was able to leave a message to call me back. I have not received any return communication.
So ordered. Yeah, and page 15 didn't appear at all.
And, Stecker, just my note, I mean, I haven't had any contact, but he FTA'd, it looks like on 2/27, so I was just gonna wait and see if he showed up, Okay.
Oh, that's right, yeah.
Oh, okay. 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 Okay.
Yeah, you had public defender up there and he was kind of letting us know, yeah. 1,000 it is, 1, 2, 3, 4, 5 cases. Yeah, oh yes. That was not. I remember that we called for Mr. Carter and there was no answer. They failure to appear. 1,000 cash or bond on Richard William Carter. Before calling the 1 o'clock calendar, there's something I need to advise you of. It's your first appearance, called an arraignment. The public defender will be here and will enter a plea on your behalf. That plea invariably is not guilty at this stage of the proceedings. That's a preservation of your rights until we can have a pretrial. Pretrial is a chance for you to talk to your attorney and negotiate the matter to a settlement if you can. If that can't be done, you have a right to a public and speedy jury trial in the county where the offense is alleged to have been committed. If you have any questions about your rights, about what you're charged with, either ask Mr. Haverco, who will be the public defender, or myself. Call a private counsel matter first. Yelm versus Victoria Ray Galvin. Is that your name, ma'am? Citation alleges that on or about April 17, 2025, you committed the offense of assault in the 4th degree domestic violence. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. At this point, I'm going to turn to your attorney for the entry of a plea on your behalf.
Thank you, Your Honor.
Sure. As a condition of release, I did set no contact with the alleged victim in this matter. Thank you, Mr. English. I understand the alleged victim, Emilio Galvin, is present in the courtroom, and he may have something to say on behalf of the no contact order.
Okay.
Yes, if you come on up, if you would. Yeah, the safety of the people involved in a domestic issue is the important thing here. I did enter a no contact order with the defendant in this case. Sometimes that's amended to no hostile contact. Your safety is a concern. Do you have anything you'd like to say about that? We don't need to talk about the case itself. The question is what do we do until the matter is resolved? Today, just a plea of not guilty is entered. The question is whether there's going to be contact or no contact. I can either leave the no contact order in effect, or I can modify that to mean that there can be contact, but no hostile contact. That's your request. City, have anything to add?
City would like the no contact.
Like to address the matter at this time?
Yeah.
Okay. No contact order will remain in effect. We're going to set the matter for a pretrial at private counsel. Pretrials are set for always 9 o'clock in the morning. Next available dates are May 8th, 22nd, June 5th.
Go ahead and do
June 5th it is. Scalvin, I'm going to sign an order resetting the matter for a pretrial on June 5th at 9 o'clock in the morning. Your counsel, if he wishes, can appear by way of Zoom, but I would like you here in person. Is that acceptable? That's
totally fine. And it's working in a prequel fine.
If you want me to. You can either stipulate to a probable cause or I can find probable cause. But...
Oh, no, Your Honor, criminal rule 3.4.
Oh, sure. I'm sorry. I think before I act, absolutely. 3.4 is that's if you want to appear that way, that's fine.
Okay.
Of course, I would for a disposition, yes, but for a discussions, 3.4 is fine.
Save my client for it. She just.
I would want the same thing.
Okay, thank you.
Scalvin, what we're saying is you just need to stay in touch with your attorney and he'll tell you whether you need to be here or not. Sometimes we'll have a hearing, your appearance won't be necessary. We'll leave it at that. Sign the order. Get a copy of today's order at the window. I'm not entering a formal DV no contact order, but it is a condition of release.
Okay,
Let's
very good.
be in touch with your attorney and we'll see you back here when required. Any questions? Have a good day.
Thank you, Judge.
Thank you, sir. Take care. Go back to the head of the calendar. Michael Anderson in the courtroom. I get no answer. How about Wade Campbell? Mr. Campbell, come on up and have a seat if you would. We'll name Wade Robert Campbell.
Yeah.
Mr. Campbell, the citation I have alleges that on or about April 10th, 2025, you committed the offense of driving while under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time and represent you throughout the course of the case should you be indigent and request his services.
You plead probable cause, Your Honor, at support the not guilty plea.
Mr. Campbell, a plea of not guilty preserves your rights, waiver of any further formal advisement, stipulation, the probable cause. Mr. Campbell, conditions of release are: do not drive unless licensed and insured. Do not drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so. Any question at all? Pretrial June 5th, that'll be 11 o'clock in the morning. I will electronically sign an order reciting that
You don't need to write anything down. Update with the court before you leave.
and I will ask everybody to leave contact information with Mr. Haverco.
So do you have a phone number? Okay, that's okay.
Campbell, that concludes the matter. Don't forget to stop at the window on the way out to get a copy of today's order, okay? And again, stay in touch with Mr. Haverco. Stay in touch with your attorney there.
Free to go, just go see the clerk. She'll give you a copy of your paperwork today.
Okay, my dismissal.
Here's one.
Thank you. Bethany Crow does not respond. How about Thomas Grzelka? I'm mispronouncing that name. I'm quite sure. Charles Hill. Mr. Hill, come on up and have a seat. Now, what I'm going to tell you is applicable to other people in the courtroom as well. Mr. Hill, you walked in here cited with the offense of DWLS third degree. That's a criminal offense bearing jail of up to 90 days in jail and or a $1,000 fine. The city may have a motion, and does in your case, is amending the charge to the civil infraction of no valid operator's license, second degree. Here's the difference. That's an infraction. In other words, no jail time can be attached. If you admit the infraction, I'll impose a fine, and that concludes the matter. If you deny that you committed the infraction, we'll set the matter for a contested hearing at the next court date. Any question about anything I just said? You're also cited for a failure to have or display proof of liability insurance. So I'm going to ask you to admit or deny the two infractions: no valid operator's license and no insurance.
Those things did happen, but I believe I was still within the limit of how long I owned the car before I needed to get it registered.
I'm not aware of any grace period. The law is if you're driving a car, whether you own it or not, it needs to be insured. You need to be, yeah, there is no grace period for getting, I can drive it without insurance for so long. There isn't any such thing. So if you admit those, the no insurance ticket, that's $459. That's way too much. If you admit that, it'll be $150 each offense for a total of $300, which you could pay at $50 a month. If you admit the infractions, that's what we'll do. If you deny the infractions, again, you're entitled to a hearing to contest the matter. What do you want to do?
I'm just gonna admit that.
I'm hoping, and I'll encourage anybody who's having an issue with their license, whether it's first, second, or third degree suspension, do what you can to get it reinstated. We live in a world where you've got to be able to drive.
Just had court yesterday, at Thurston County District Courthouse to get my license back, so.
That is a help. Have you checked? Do you need to pay a reinstatement fee of any kind, or?
Yeah.
And here we are adding to the misery.
Yeah, it's not working.
Well, $25 a month then. No, to me, it's much more important that you get your license reinstated. If you can't make the payment, if you got to satisfy some other obligation first, let us know. We can certainly work with this. I want you to concentrate on getting your license back. We'll set it at $25 a month, starting first payment May 24th. But just let us know, as I say, if there's a problem. Mr. Hill, I'm signing order to the effect of the ruling. I want you to get a copy of the order at the window outside the courtroom, and good luck to you. Yeah, I'd make getting reinstated and it sounds like you're doing that, a project in life. Take care of yourself. Jonah Hofecker does not respond. Catalina Curlin. Good afternoon, ma'am. Catalina Michelle Curlin is your true and correct name?
Yes.
Citation alleges on or about April 18th, 2025, you committed the offense of violating an order restricting contact. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for the offense of driving a license suspended, revoked, third degree. And you may have heard me say that's a 90-day and or a $1,000 maximum penalty offense upon conviction. I'll appoint Mr. Haverco to represent you in this matter, Ms. Curlin, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty pleas.
We're going to set a pretrial for June 5th. Ms. Curlin, I want you to give contact information to Mr. Haverco. His contact information is going to be on the order for today. Curlin, that concludes the matter. Get a copy of the order at the window, and we'll see you back here June 5th. Take care. Caden Kanek, KNAACK does not respond. Charles Marta. Mr. Marta, come on up and have a seat if you would. Full name Charles Stephen Marta.
Yes.
Mr. Marta, the citation I'm looking at alleges that on or about April 5th, 2025, you committed the offense of driving under the influence of intoxicants, gross misdemeanor, the maximum penalty on conviction, 364 days in jail and or a $5,000 fine. Ah. I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf and you can discuss that with him.
Stipulate probable cause, Your Honor, as the court to enter not guilty plea.
Mr. Marta, plea of not guilty, preserves your rights pending to pretrial. Conditions of release are don't drive unless licensed and insured, and don't drink and drive. Any officer asks you to take a breathalyzer, you're to do so. Oh, sigh. That's all. Talk to your attorney about that.
You have a phone number? I don't know, can you still drive for now, Your Honor?
As far as I'm concerned, unless the Department of Licensing has taken some action,
They said, name.
I know there are no prior convictions.
First time. And I own a paint company. You might want to talk to the DOL about either an interlock license or some kind of working license, you know, but that's between kind of you and DOL, so you need to. Oh yeah, I have an interview set up a phone interview, paid $375. Go and sign him.
That should take care of it.
This will never happen.
That's,
Oh.
again, that's something to talk to Mr. Haverco about. So,
You did. Yeah, you're done. Yeah, before you go see the clerk and she'll give you printed out copies of everything too. I'll be contacted.
Mr. Marty, that concludes the hearing. Get a copy of today's order at the window outside the courtroom and to your left, and good luck with the Department of Licensing, getting yourself back on the road legally. Take care of yourself. See you back here on June 5th. Have a good one. Andrew McLeod. Does not answer. How about Joel Navarrete Sierra? Good afternoon. Is that your full name, Joel, middle initial N, Navarrete Sierra? If I mispronounce your name, I apologize.
No, that's fine.
Citation alleges that on or about April 19th, you committed the offense of driving under the influence of intoxicants and also drove with no valid license on your person with no identification. You're also cited for the infraction of no insurance. I'm going to appoint Mr. Haverco to represent you. He's going to enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights, as I indicated. Conditions of release are, as earlier said, don't drive unless licensed and insured, no drinking and driving at all. And any officer asks you to take a breathalyzer, you're to do so.
Yeah.
Excuse me.
Also, I have insurance. They just never asked for it. Oh, sorry.
We can take that, we'll take that up. We're continuing that matter along with the
Contacting. No, not quite. Silent.
Before you go, just stop by the clerk's, the clerk, and she'll print out copies of everything for you.
Mr. Navarrete, Sierra, thank you very much for appearing. Again, yeah, as Mr. Haverko said, get a copy of the order. Holly Riddall. Good afternoon, ma'am. Full name, Holly Noel Riddall. Ms. Riddall, the citation alleges that on or about April 15, 2025, you committed the offense of reckless endangerment. That charge is a gross misdemeanor. Maximum penalty on conviction would be 364 days and or a $5,000 fine. I'm going to appoint Mr. Haverko to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate probable cause, Your Honor, ask the clerk to enter not guilty plea.
Mr. Riddall, a plea of not guilty preserves your rights pending the pretrial. Any conditions released remain in effect. So we want there to be peace in the neighborhood. Riddall, I've signed the order resetting the matter for a pretrial on June 5th. Get a copy of the order at the window and we'll see you back here on June 5th. Any questions? Take care of yourself. Chanel Nicole Robledo. Is Chanel Nicole Robledo your full name? That's it. This is another driving license suspended, revoked, third degree. The city's amending that to no valid operator's license, second degree, which, if you were paying attention earlier, makes it an infraction and not a criminal offense. If you admit the infraction, it's a $150 fine. If you deny that you committed the infraction, we can set it for a contested hearing. Any question about anything I just said? Yes. Yes, it's an officer's, and I've seen it's a relatively minor criminal offense, but it's still a criminal offense, which means, yes, if the officer sees fit to do so, he can book you into jail on bail. And I've seen Yelm officers do that on the same offense that you're here for. He did indicate, or it is indicated that you were pulled over on April 17th and warned about driving while you were suspended.
So
Now, this is something you ought to talk to Mr. Haverko about. I just want to caution you that, well, bear in mind that we live in a world where you've got to be able to drive. If there is an issue with your license, what you need to do is get that taken care of. If there's an admission to the infraction, I'll assess a $150 fine. That concludes the matter. So ordered. Payments will be $25 a month, beginning probably May 24th. You know what you need to do to reinstate your license? Yes, that's where you start. Go to the Department of Licensing and find out what you need to do. That could be any one of a number of things. Mr. Robledo, I'm signing the order on today's hearing. I want you to go to the window out in front and get a copy of that, and good luck getting reinstated. I'm hoping that happens soon. Take care of yourself.
Yeah.
Jeffrey Sanders does not respond. Paul Segura is here. Full name Paul Anthony Segura. Mr. Segura, the citation alleges in honor about April 14th, 2025. You committed the offenses of assault in the 4th degree, which is a gross misdemeanor, the maximum penalty on conviction, 364 days in jail and or a $5,000 fine. You're also cited for resisting arrest. That's a simple misdemeanor, the maximum penalty, 90 days in jail and or a $1,000 fine. I'll appoint Mr. Everco to enter a plea on your behalf. He'll do so at this time.
They played the probable cause, Your Honor. Ask the court to enter not guilty, please.
Mr. Segura, that's,
Okay.
I believe I'd ordered no contact with Becky Hufel. Is she in the courtroom? Do you wish to address the court on that? Go ahead and stand up. Identify yourself if you would for the record, and tell me what you want to hear, what you want me to hear. You're Becky Hufel? Okay, speak up a little bit. Okay, I'll try to speak up and you need to do the same, but go ahead. Boy. Okay. Now, right now, we don't need to talk about the case at all. Right now, my concern is safety of the individuals. I want you to be safe, not in trouble. And so I have ordered no contact. I can change that to no hostile contact. I can modify the order. What do you want me to do? How about if I ordered no intoxication, no drinking? Bad day. Mr. Segura, that's your wife asked what no hostile contact means. That's not capable of any precise definition. I'll tell you this, if there's a problem, the police their attention gets drawn to the situation, guess who's gonna go to jail? I'm looking at them. So yeah, it's up to you to keep the peace. No, I don't want any hostility, any bad interaction. If things get to the point where it looks like that might be on the horizon, leave. Tennis you the place. That's. Oh, I can set conditions of release on a pending matter. I can't order anybody to, take treatment, no matter how good of an idea I think it is. I would certainly encourage Mr. Segura to talk to you and to his attorney, to Mr. Everco, about would it be a good idea to approach the situation.
I'm currently involved in external services. My therapist took a leave of absence.
I'm gonna leave that up to you and what you think is best to get yourself where you should be. We're gonna set a pretrial on this matter to June 5th. You've got a lot of support, a lot of help here. That's a lot of people don't have that. They don't have anybody that cares what's going on in their life. If somebody's reaching out their hand to give you help, it's a good idea to take that hand. At least it's your choice, but I want you to think. That was all our lives could stand improvement one way or the other. It's that concludes the matter. We'll see you back here on June 5th for your pretrial. Stay in touch with Mr. Haverco. Yes.
Why be able to get a copy to the updated system?
Let me get back to that screen. On this motion, do I need to fill in? I have signed the order of Mr. Segura rescinding and you can get a copy of that order at the window. We can't do anything immediately here, but and a condition of release is no hostile contact. Again, that's a condition. That's not of record anywhere that any law enforcement can get a hold of it. But I will tell you that if there is an issue, if there is an allegation of no, and I'm satisfied that there was, you're not going to be happy. You don't want that to be. Don't want that to happen. Any question at all? Good luck to you. Get a copy of the pretrial order and the copy of the order modifying the formal no contact order at the window. Okay, Mr. Segura, thank you, and we'll see you back here at your next court appearance on June 5th. Good luck, and thank you, ma'am. Jason Shorts. Good afternoon, full name Jason Dwayne Shorts. Sure. Mr. Shorts, citation alleges that on or about April 12th, 2025, you committed the offense of driving under the influence of intoxicants, gross misdemeanor, maximum penalty on conviction, 364 days in jail, and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, as to court enter not guilty plea.
Mr. Short's plea of not guilty preserves your rights. Again, no drinking and driving, no driving unless licensed and insured. Any officer asks you to take a breathalyzer, you're to do so. Pretrial is being set for June 5th, 2025 at 11 a.m. Signing an order to that effect. I want you to make sure Mr. Haverco has your contact information, and his contact information will be on the order that I'm generating today. Here's that concludes the matter. If you've exchanged information, go ahead and get a copy of today's order at the window, and we'll see you back here June 5th. Any questions at all? Take care of yourself. Tennille Squally is here. Good afternoon, Tennille. Might indicate I know Ms. Squally from Ms. Squally Tribal Court, willing to preside over the case as long as there's an agreement as to what's going to happen, or if anybody has any objection to be sitting here. Hearing no objection at this point, Ms. Squally was cited 2 times for DWS third and also given a no insurance. I'll defer to the city.
City's gonna make its most of it.
Maybe somewhat reluctantly, Tennille, with that in mind, you now have 2 counts of no valid operator's license on your person and 1 count of not having insurance. And also it looks like, no, that's, I'm mistaken, a speeding ticket. You know what you need to do to get your license back? Money. And I know the tribe will help you out if need be. Well, they'll help you out too. That's well, let's make it, oh gosh. 150 and 150 and 100. 150 on the each no vol and 100 on the speeding ticket. 25 a month starting May 24th. Now I'm aware of the income that's involved given your affiliation. But yeah, the important thing here is, you know, we live in a world where you got to be able to drive. I'd make it a priority in life to get your license. And of course, it's not a good idea to speed when your license is not up to snuff. Okay. I'm signing an order to that effect. Ms. Squally, I'm going to wish you the best of luck. I'd make a reinstatement of your license. I'd make it a priority. And like I said, and you know, it's just money. It's money. Pay the money, get your license back, and don't give any officer any reason or excuse to pull you over. Okay? That's, yeah, you can't defend on relatives and boyfriends. Be a chauffeur all the time. So good luck. I've signed an order to that effect. Tennille, what I want you to do, get a copy of that at the window, and good luck to you and get reinstated. Thank you. We will. Take care.
Mr. Shorts? He's on his 5th BOA.
No.
Oh, Tennille?
Alani Thomas will come back to that matter. There's a note in the file on that. Haley Wilhelm, neither of them answer. We'll deal with that on the when we issue warrants. It is just a little early, but we'll call the 2:30 mitigation calendar. First, I have Ashton Holmes. Mr. Holmes, good afternoon. You were cited for expired registration, greater than 2 months, and operating a vehicle without liability insurance. First, excuse me, the registration, have you gotten that taken care of, or
Yes, Your Honor.
how about the insurance? Did you
Yes,
have
Your
it? Have you gotten it since? What's your?
So I was working on getting both of them, bad timing, and I got him, I ended up calling my boss and told him what happened. He forwarded me some money and I got it all taken care of. Insurance that day and then tabs the next day.
Great. Boy, that's the registration, that's 237 and the 559 on the insurance. That's way too much. Let's reduce that to 100 on the expired registration and 150 on the expired insurance or insurance. And you can pay that monthly, make monthly payments. Important thing is make the payments or let us know if you can't. Yeah, the insurance, it's an expense, but it's something, if you need it, you need it badly. That's no question about that at all. $25 a month, first payment due May 24th. Any question at all? Yeah, they aren't the most serious charges in the world. It's more of kind of your papers are not quite in order yet, but that's the rules we operate under. What I want you to do, Mr. Holmes, is get a copy of today's order at the window. And again, if you can't make the payments, let us know, okay?
Thank you, Your Honor.
Take care of yourself. Kristen Van Hull. Good afternoon, ma'am. What now?
The older I get, the more nervous.
Well, I could say the same thing about me.
Your Honor.
But I think the older I get, the less nervous I get.
I understand that driving is a privilege and I don't deny that I committed 2 infractions. I had a perfect driving record and have never been cited for driving without proof of insurance. On February 8th, it was extremely cold outside and my boyfriend woke me up in the middle of the night, freezing cold, literally, and stranded in Yelm.
What happened?
He was stranded in Yelm. His vehicle broke down and he was out in the elements all day long. So I felt it was urgent that I get to him. And that's why I think I was speeding, because I had that sense of urgency. I most often drive the speed limit, if not a couple miles below the speed limit. I had an auto insurance policy, but I recently received a new debit card and failed to inform my insurance company with the new card information for payment. And that's why it lapsed in coverage. And could you please dismiss these tickets under these circumstances? I normally don't drive in the middle of the night and I also don't speed. I mean, I'm just like, my driving record was perfect.
These things happen. You now have insurance.
Yes.
Yeah, well, the speeding is that's a moving offense, and of course that would affect your insurance company. You do have the right to defer it. A deferral is something you can do every 7 years with regard to a moving violation. Those are the ones that hurt your insurance records, of course.
Yeah.
Every court does it differently. If you wanted to exercise your right to have a deferral on the speeding ticket, every court does it differently. The way I do it is this. The cost of doing the deferral are $100. Want you to attend driving safety school, you can do that online. I think that costs about 30 or 40 bucks. You do that and have no infractions over the next 4 months. Case will be, the citation will be dismissed.
Okay.
On the insurance, it's important, have or display. You've got to reinstate it, so I'm not real excited about that one. We'll just include that in the deferral and get them both dismissed at the end of four months. You indicated you don't have any driving record?
I'm sorry, do I have?
You
what?
don't have a driving record? No.
I
no.
don't have anything on my driving record. Well, I have, when I did my insurance, I told them that I had these 2 infractions and it just went, it's really high right now, my insurance. But besides that, I don't have anything on my record, no.
Well, this won't go on your record. Shouldn't have told them you had these infractions because until they're found to be committed, you don't. It's
Okay,
but anyway, that'll be the ruling. You can defer them and get them dismissed.
okay.
And that's, I think that's the right thing for you to do.
So you're allowed for this particular case for the infractions, I'm allowed 2 deferral or the deferral?
One deferral. You're allowed to defer 1 moving violation and 1 non-moving violation every 7 years.
I'm trying to think now, it's been a while, I'm trying to think what year it was, so, I did a deferral, but it was it wasn't for.
You're eligible. You're eligible.
Okay.
No, that's, I have a docket entry but
Okay, okay.
my clerk is excellent at checking on these things.
Okay, cool.
And she checked and you are eligible for that.
Okay,
I don't see much point in deferring a non-moving violation because it doesn't have that effect on your insurance company that a moving violation does.
okay,
And sometimes if you've already used your deferral and get another ticket, some prosecutors will amend a moving violation to a non-moving violation so that can be deferred as well.
okay. Now,
Don't need to worry about that here.
what happens if I do get a ticket though? Does this count? It all comes back up? Is that how that goes?
What happens, well, we're kind of back to square one. It's no longer deferred. Deferred means put off. We're back to kind of back to square one.
And then I would pay the tickets, these tickets?
Well, I would still have the authority to mitigate, to reduce the amount.
I just don't want to get in any more trouble. You know, I just want to get this taken care of.
As long as you don't get any more tickets over the next 4 months, you won't be in any trouble.
Okay, I can do that. Thank you, you're very kind.
Ms. Van Hol, that's hey, you didn't get any wreck or anything. Driving, of course, is about the most dangerous thing you'll ever do in your life.
I know, I also want to drive,
Yeah, that's
but I'm done.
unfortunately, I am signing an order reflecting and have proof that you've done that driving school, traffic safety school. Do we have information on that? You'll get that at the window. That's
Okay,
it. But go ahead.
go to the clerk.
I've signed the order. Go ahead to the clerk's window outside and to the left, get a copy and come back in if you have any questions. Thank you for appearing, Miss. Take care. Morning, sir. Raymond Varney, I'm assuming. You've got 2 non-moving violations, registration 237 and registration and plate violation as well.
I have all of it taken care of.
That's all taken care of.
Yeah, I called, my lawyer was supposed to deal with this, but he said it's just cheaper for me to come in and do it.
Oh, yeah, I know what a lawyer charged to appear on an infraction. You are. I'm going to reduce it to 100 each
Okay.
for a total of
Could I
200.
pay that here today?
Part?
Am I able to pay that here today?
You certainly are. You can pay it over time, but if you want to take care of it today, Mr. Varney, you certainly can.
That'd be great.
That's it. Yeah, that's minor offenses. And the good thing is they're non-moving. If it's moving in terms of the impact on your insurance rates, it's lawyer's probably a better choice.
Okay.
Everything's electronic. I've now signed the order. Get a copy of it at the window. And yes, if you want to pay it today, you certainly can. Get it paid for. It's out of mind, out of sight.
Thank you.
Mr. Varney, thank you. You take care of yourself. Happy motoring. Take care. And with that, we can go to the 1 o'clock no-shows. And Mr. Sue's matter, that was the one that was continued this morning. That's it. Docket number 1 did not show up. Michael Anderson. There is a note in the file. He couldn't make it today. So reset without, with notice sent. Next one is Bethany Crow. That's the, I think we've had some multiple calls on that. Reset it out 2 weeks for her to appear in person. Next is 5 and 6, Thomas Grizelka. Amend DWS to no vol 2 and FTA it, and FTA the no insurance ticket. Next would be Jonah Hoffecker. I'm not finding a PC on that one. I'll talk to you later about that. Dismiss that charge. Next would be Caden Kanak, docket number 12. Amend DDoS 3rd to no vol 2 and FTA it. Next one we have is Andrew McLeod. He had promised me he would appear without fail. 1,000 cash or bond, probable causes previously found on him. Next would be Jeffrey Sanders. I do find probable cause for the citation to him for no ignition interlock and DDoS 3rd, 1,000 cash or bond. And after that, Alani Thomas, and yeah, reset that one in 2 weeks, requiring in-person presence. And last would be Haley Wilhelm. I find probable cause for theft 3rd and crim trust 1, 1,000 cash or bond. Warrant will issue. And unless I've missed somebody, I was talking to Dan and Garrett at the same time.